Sorry, it's my fault. I'm just remarking. Perhaps it's personal. It's very warm in here.
I had the same reaction as I came in.
Oh, I'm glad you did. I think it's that dial there.
This one here.
Background temperature. Even.
Yes, thank you.
I'm very grateful.
We're going to take a break halfway through.
Yes. Well, Lords, my lady, I said I would start with the FCA as a whole, and that's to be found core bundle page 151. And I'm beginning at the top of that page with the title. And the words are final clearance agreement. We say those words are important because what this agreement is to provide for is a final clearance of debts. And we know what clearance means in terms of debts, either paid or written off under the terms of the agreement, but not left hanging. Everyone is to know where they stand. You'll see that the relationship is coming to an end. So it's a clearance of debts, and it's to be a final clearance. It's intended to give certainty and finality. These debts have been outstanding for far too long. We'll see from the defendant's own evidence that he wanted to finish it up, his words, his issue with the fees. So we say that that title, very first words you come across in this agreement, tell you its purpose, clearing the debts on a final basis. The parties are then recited, and my lady, you had an exchange with my learned friend about why the defendant needed to be included at all. And I think you suggested, well, that would add to the pressure, the more the merrier. Of course, on the defendant's construction, he's under no pressure, there's no obligation.
Yes, no, I realised that when I said it.
Oh.
But don't worry.
So then the question, but I think it's instructive that one's first reaction is that to make him a party indicates that he's coming under an obligation. That is why we naturally think that someone is being made a party to an agreement.
Well, it's not the
Well, it
case
gives
with
him
an option.
rights.
If it's not the case, if it is an option.
No, it gives him rights. It can give him something or take away something.
Yes, if the rest of the agreement takes you to that place, indeed, but one's natural reaction is that he's being bound for the purposes, as you say, of either being given rights or being put under an obligation.
Well, we're talking about pre-existing debts here, so I'm not sure one's natural reaction is that somebody is going to be making themselves personally liable for 60 million Saudi riyals. That's not a natural reaction, is it? The natural reaction is that they wouldn't want to be making themselves liable for somebody else's debts.
Depends what the rest of the agreement says it's going to achieve. So if it's going to clear those debts, then it might well be said.
There are other reasons why he would want to be a party. For example, and I'm just using English law as an example here, because obviously we don't actually know what law this was really intended to be governed by. If I was gratuitously planning to pay the debts of somebody else in order to give myself a right of subrogation reimbursement, I would need to take various steps. If there was a promissory note, for example, I might want to take an assignment of the promissory note if I've paid off debts of somebody in order to then have a right to enforce back against them. So there are a number. If you get into the very interesting business of paying off other people's debts, you might very well want to make yourself a party to an arrangement which gave you a right, for example, to delivery of the promissory note.
Yes. I think for my purposes, it's enough to say that the suggested reason of increasing the pressure doesn't fit with the defendant's construction, that he's actually not under any pressure at all.
Why was trading not a party? Can you shed any light on that?
I'm not sure I can shed any light on it. I can tell you that the dates of the insolvency processes are given in the judgment.
Yeah. They're much later, aren't they? So that wasn't a bar.
Exactly. And hospital, it's over 2 years later. It's December 19 that enters bankruptcy. So that's not the reason. I can't shed any light on why trading isn't a party there. after the parties, and I think it's common ground that the reference to in his personal capacity in Party 2 includes the defendant in his personal capacity. We then have the preamble, and the first recitation then is that the first party is a creditor of the second party's father, pursuant to a legal services contract concluded between them. Just pausing there was an issue below about whether this FCA was only concerned with debts under the promissory notes. The judge found no, it wasn't on its proper construction. It addressed debts under the prior retainer for which the father was liable. And although there was an attempt to appeal that finding...
No permission.
No permission, exactly. So we are concerned with debts under the legal services contract referred to in the first line of this recital. And that legal services contract is said to be fully executed for the benefit of the father. That's relevant because there was a suggestion, both in the defendant's witness statement and at trial, that the claimants hadn't come up to proof on the sums they claimed, and there was some dispute about the quality of work. So what this settlement agreement is saying, an agreed basis between us, and you see it in Clause 5 as well, is the work has been done. The contract's been fully executed. And we say that's consistent with the idea that the parties are getting finality, they're getting a clearance of the debts. Then there's the statement that the father has failed to pay. And then there's the statement that the second party has pledged to pay these debts on behalf of its father. And we'll come back to the word pledge, but I do say that that brings with it an idea of almost solemnity, but it's certainly promise, it's certainly agree. It's not a word that you'd use to give someone an option.
Is it talking about the past, or is it talking about the present?
In my submission, the present. There's no suggestion in the evidence that this could be referring to a prior, i.e. before the FCA.
Well, it wouldn't be a question of evidence, would it? And we are looking at objective construction.
Yes, well, there's no suggestion in any of the admissible aids to that construction that there's a prior agreement.
Well, there were prior agreements, we know that.
Sorry, a prior agreement under which he had pledged to pay the debts of his father. So in my submission, that must be referring to the agreement contained within this FCA.
You have to read that sentence as a whole, don't you? Whereas the second party has pledged to pay these debts on behalf of his father and has prepared a number of promissory notes for the first party which are now payable. So I don't think that's talking about the present. It's not saying he hereby is pledging. It's definitely talking about the past, isn't it?
The difficulty for me then is, has prepared a number of promissory notes. Well, obviously my predecessor tried to argue that he was liable under the promissory notes, and that wasn't upheld by the judge. So we don't say that he's liable under the promissory notes. Maybe just the tenses have got a little wrong here in the preamble. I'm certainly not submitting to you that there's a pre-existing agreement under which he's personally liable.
No, I think we're all... I just want to really understand... I mean, I
what that
understand,
sentence means.
I think what you're suggesting is that the wording, whereas the second party has pledged,
Yes.
is something that supports you.
Yes.
But the difficulty with that is that it doesn't seem to me that that is referring to what he is doing in this agreement. It's referring to the past. Now, it may be that it doesn't make sense, but it seems to me a lot of this agreement doesn't make sense.
That may be right.
And it may be it's referring to it in an informal sense. He's pledged to, not a legally binding sense, because, or it may be referring to the fact that he signed the second party, of course, includes him on behalf of Sard Hospital.
Yes.
And of course, in that context, he did pledge on behalf of Sard Hospital.
Well, that's right. Pledging to pay on behalf of his father.
Yes, that's what's missing there.
Maybe.
Yes, sorry.
Those are the words, exactly. It may be that I can't take that point any further because the wording isn't clear enough either way. The recitation backwards would suggest a prior agreement.
Sard Hospital did it on behalf of, in a sense, did it on behalf of the father, didn't it?
Well, no, on behalf of Sard Trading. It's guaranteeing the promissory notes.
Yes, but Sard Trading they're all liable for the same fees, aren't they?
I'm not sure we can go that far on the evidence.
Well, trading has given, as I understand it, an independent obligation by way of promissory note. I will pay the bearer on demand the sum of.
Yes.
I mean, and then it's left presumably between the father and trading to figure out what, if any, relationship there then, following payment under the promissory note, there would have to be of the legal services, the fees, in other words.
Yes.
I know there's an interesting question about the basis on which trading even felt corporately able to give the promissory notes.
Yes, I think in answer to my Lord's question about whether these promissory notes could be termed payment on behalf of the father, in my submission, I'm not sure they can be termed that. They are separate obligations, and I don't think we have the evidence to be able to say actually the trading and father are coextensively liable claimants.
Well, can we leave this? I mean, I think you're praying in aid those words to support the suggestion that he is taking on a liability in this agreement. And we hear that.
Yes.
But can we leave it that it may support you, it may not. It seems quite ambiguous.
Yes. I think I'm going to read to the rest of the sentence and the wishes to settle, and say that whatever one takes about the backward-looking tense, again, the wishes to settle undoubtedly looks forward, because we have then the sentence I'm about to come to, whereas the second party wishes to settle these debts, both parties have agreed, being fully competent, to conclude this agreement to govern the settlement arising between them.
I mean, on any view, the second party, even if you were right about the forward-looking nature of the first part of that sentence, whatever else he did, the second party didn't pay the full amount of the outstanding debts on behalf of his father. He didn't pay these debts.
No, that's right.
He paid he undertook only to pay an amount equal to a proportion of those debts.
Exactly, which is why I begin to think that actually this is trying to get at the fact that he's pledging under this agreement. So you need to look at the rest of the agreement to see actually what the pledge is. And that takes you to clause 6.
Sorry, I didn't follow that.
No.
Could
I'm sorry,
you say that again? It's my
Yes,
fault.
the suggestion I think from my Lord was he's not pledging to pay all of these debts. So the words, whereas the second party has pledged to pay these debts on behalf of his father,
Yes.
these debts can't refer to everything, because the FCA doesn't include a pledge to pay.
No, I disagree.
I
Because
think it works the other way,
respectfully,
yeah.
it's the other way. In settlement, i.e. on a discounted basis, to settle these debts, having agreed to conclude this agreement in order to cover the settlement arising.
Sorry, I was on the pledge to pay these debts reference.
Yeah.
Yes,
That's
that's
what-
pledging to pay. Sorry, pledging to pay these debts.
Yes.
Is a reference to all the debts of the father, are they not?
Well, yes, but
Certainly not in quantity.
exactly.
I mean, he's not. The promise by the second party to pay is not these debts, either ones which have just been identified in the opening 3 lines, because the debts identified in the opening 3 lines for which the first party is a creditor of the second party's father, under the legal services contract, as I understand it, amount to 90-something million.
Well,
That's
even
the
possibly
promissory
more.
notes.
Promis-
That's the promissory notes.
But
Exactly.
That's the very point.
So the promissory notes are 91 million.
Yeah.
There's no pledge to pay that amount.
No.
So it has
Not
pledged-
in this agreement. But,
and,
that's,
and not at all.
but I think we're getting slightly.
We may be getting
Slightly-
distracted by arguments.
Yes, I think the point is the reference to the second party has pledged to pay these debts does not on its face appear to be a reference to anything agreed to in the instant final clearance agreement. I don't see how it can possibly be, because you say he's not pledging to pay all his father's debts, and it's also in the past tense. linked with preparing a number of promissory notes. For my part, I said before it was ambiguous. I mean, if I need to go further, I don't think it helps you at all, in my own view. I'm not saying it's against you, but it doesn't help you.
I'm not going to take it further in that case. I'll stick with the wishes to settle. So, wishes to settle, we end up with a settlement. The words govern the settlement. And again, I say that word, the settlement, is consistent with the title and with the concept of finality.
Yes, but also settlement doesn't necessarily require you taking on liability.
No, but you wouldn't expect in a settlement, all that is being agreed is someone given an option at his whim to pay certain debts, and no one would know where they stood.
Well, a settlement could mean anything. You can settle on all sorts of different terms.
Well,
You can reach an agreement on all sorts of different terms. Contingent, absolute, finite, indefinite.
yes.
And it's settlement arising as per the following terms and conditions. So does it really take you any further?
Well, obviously when we come to the following terms and conditions, I'll be saying that the need for certainty informs how one reads Clause 6. But that may... It's the preamble, it's the introduction. But I do say that a settlement and a heading of final clearance agreement gives you the idea that you're looking for certainty as a result of what the parties have agreed.
Forgive me, where does that take us? Because at the end of the day, there is no doubt, I think both parties agree, that either automatically on non-payment or at your option, this settlement agreement could be deemed null and void.
Yes.
So it isn't undoubtedly certain and final on anyone's analysis.
But from the creditor's analysis, and the same as all the other cases, the creditor is then given the option. So the creditor gets the ability to say, I'm going to hold you to the agreement that you've reached, the 16 million, or I'll declare this void.
But there's no absolute certainty of outcome on your construction.
So the creditor gets the ability to choose.
And who knows what they'll do.
That's true, but it's in the creditor's choice.
Yep. So the mechanism is final, but the outcome is uncertain.
Objectively uncertain, yes. But just as in all of the other cases, the commercially sensible reading is that the creditor, the one entitled to the money, is the one able to choose whether it's void or not.
Well, if the defendant doesn't pay, the only thing you gain from this agreement, in your case, is a right to go after him for 60 million.
Yes.
So it's not a final settlement agreement. It's, from your perspective, the only thing it gives you is an additional right of action against the defendant.
If he doesn't pay, that's right.
He doesn't pay.
Yes, if he doesn't pay, we then need to exactly take an action against him.
Yes.
But what the parties are saying at the outset...
They've always, the defendant has always had the option, either himself or through the companies, of repaying this debt. What this gives, on one side, is gives him and the companies the right to pay only 60 million rather than 90. And it gives your clients the prospect that because they're going to accept 60 rather than 90, they might get it. And if they don't, you say they have a cause of action against the defendant.
Yes, so what the defendant says is that the creditor gives up all of his rights in exchange for the possibility of payment.
Doesn't give up all his rights.
Well, that's the submission in the defendant's skeleton argument.
Well, retains his rights to recover the full amount against others.
In circumstances where he chooses, under Clause 4, to declare the agreement void. Yes, absolutely. But while the agreement's in force, and this is the commercial bargain that the defendant is saying actually has been struck here.
Well, what's commercial about it? Why should he take on a liability for 60 million that he need never take on?
Well, as the judge explains, this is a group of companies. His fortunes are intertwined with his father, is the word the judge has used here. And as partner in the sense of shareholder. He has a vested interest in the success of the companies. He explains fear for himself of personal liability if they are enforced in JDEC, and I need to come back to this point about...
That would all be consistent, and I'm sorry to interrupt, with a volunteering payment, but very different to undertaking a personal liability outright to pay vast sums of money. So one could understand, as I say, volunteering or having the option to pay, because it's a group of companies and their fortunes are intertwined. But that's a world away from taking on a formal legal obligation to pay, isn't it? A definite, unconditional obligation.
It's certainly a different thing. It is consistent with the promises that we see him making in advance, though, which are, I'm going to get money in by way of a loan to me, for example, or the family's jewellery will be sold, we will pay.
That's all consistent with volunteering to pay for emotional and or sound commercial motivations. But
yes,
it's just that's a world away, as I say, from undertaking a legal liability of the sort suggested.
But it's also consistent with a negotiation that says, all right, if that's what you want, if you want 60 days to pay, we'll hold you to your promise. And we will impose on you an obligation to pay. If you're going to say to the claimants, I want 60 days, I can raise this money, I'm going to pay you myself, then...
So the key thing from your clients was getting the defendant on the hook, is that right?
The key thing for my clients was finality, certainty, and getting the debts paid. Now, whether that's through the means of putting the defendant on the hook, whether it's in fact through the means of anyone else paying, they probably wouldn't have minded. But this agreement certainly puts him on the hook. And indeed, that's the reason why you've got all the arguments of duress and undue influence. Because what is said under those arguments is he did agree to be put on the hook, and there was real pressure applied to him to achieve that. So we do say there's a commercial reason for the claimants to say, all right, if you're promising that in 60 days you can pay us, we'll put that in writing, and if you don't, there will be a consequence. Well, step one, you're undertaking an obligation. That's the first thing I need to satisfy you of.
And so the way you do that is by saying, if the payment isn't made, this agreement will be null and void.
Well,
seems like a rather odd way of lawyers going about getting somebody on the hook.
Well, getting them on the hook, you look at clause 6, and then what happens if they breach it?
Hang on, that's the second question, isn't it? The first question is there an obligation?
Yes, and my answer to that is clause 6 does use words that impose an obligation. So clause 6 is
No, but forgive me, you have to look at clause 6 together with clause 4 and see that this seems to be structured that if the settlement amount isn't paid in full, this agreement is null and void. And then you look at what the settlement payments are, and you can't say, well, those impose an obligation without having to take into account that it's already been said that if they're not paid, the agreement's null and void. See, you do have to grapple with the fact that you've got both clauses.
Yes, absolutely. But what I'll say is when you look at clause 4, that's entirely consistent with there being a prior obligation. So if you look at clause 4 and the wording of failing to adhere and the wording timetable agreed upon, both of those separately indicate that we are talking about something that has been agreed as an obligation. Now, I agree there's a separate question for you, even if there were an obligation imposed under clause 6, whether you would still read null and void in the sense the defendant wants you to read, which is automatically void. But I do say that the wording of clause 4 is consistent with a prior obligation being imposed under clause 6. And that is what the judge concluded, that clause 6 imposes a primary obligation. It's not a contract of guarantee or anything like that. So there is a primary obligation under clause 6, even when read together with clause 4. That obviously doesn't get me home, but I do say that when one reads the agreement as a whole, step 1, is there an obligation on the defendant? Answer yes.
Well, see, clause 4 is a classic provision, isn't it, which says that the settlement is full payment of the debt. But then if you don't pay it, if you don't pay as per settlement terms, basically you lose the benefit of the settlement and it's all payable. That's what it's saying.
Can I? Yes, that's right, and that begs the question then, if it's not paid,
does the defendant personally then remain on the hook for the settlement amount, even though the full amount has not been paid?
well, it will then be the option of the creditor, either to keep the agreement on foot, and so the defendant will be on the hook for the 16 million, or to declare the agreement void and turn to the other parties. I mean, that is a commercially sensible construction. The creditor is then saying, I'm going to have the ability to choose at that point of default which route I go down.
Why don't you read clause 3, clause 4 and clause 6 in the following way? Clause 4 is the critical operative clause. It's the central clause. The way this agreement, I'm putting to you this proposition, right? Sorry, I'm not saying this is it, I'm just putting the argument.
I understand.
Clause 3 sets out a settlement amount, i.e. what we will accept.
Yes.
Clause 4 says, if you pay that within 60 days, then it will be considered full payment of the previously described outstanding debt. If the second party fails to adhere to the timetable agreed upon, in other words, it signals that clause 6 is really just a timing, it's just a timetable being agreed. That's the time you've got to do it. Then we're back to the full amount without deductions. The settlement is deemed null and void. So that really, clause 6 is simply a timetable. It's an agreed timetable. So it's an odd place to find on your argument, primary obligation in clause 6. You say that's the meaning of the word pledge, but we've seen that pledge can mean a number of things in this agreement. But clause 6 is really just setting out the timetable that's been agreed, whereas the operative provision is clause 4, isn't it? Well, that's the argument, I think, that's put against it.
It is. And
it's actually standing back a little bit further and just say, clause 3 tells you, what we'll take as a compromise.
yes.
Clause 6 is an agreed timetable, but the operative clause is actually clause 4, and that spells out what you've got to do by when and what happens if you don't do it. And that's the structure which is put against you, I think.
But then you'd be reading into clause 4 all of the words, what you have to do.
Not really. It just says if you don't agree to the agreed time, if you don't adhere to the agreed timetable. It doesn't say if you fail to pay, if you breach the clause. I mean, where is the actual payment obligation?
And grappling with that, in a final clearance agreement, you are looking for for an obligation, and that's the right starting point. And then you look at clause 6, and you find the second party pledges.
Well, you look at clause 3, don't you?
Well, clause 3 is
that's
declaring the amount, the settlement sum, if you like.
The debt's been settled. That's
Yes.
recording the agreement, setting out the agreement.
That's right, but it's not telling you anything about what then happens. So we've agreed the 16 million US.
Mm-hmm.
What's to happen next? You do then need to find in clause 6 what's to happen next, and the answer is it's to be paid according to a timetable. But the very words "it's to be paid," encapsulating pledging, there is an obligation. The second party is undertaking an obligation there. My Lord, can I come back to your question about clause 4 and that being the operative, the central clause? And when you put to me the first sentence, you said, if you pay, ...
Well, this settlement, meaning the one that's just been described in clause 3, i.e.
Yes.
the settled amount. You seem to use the word settled as to describe, as it were, some form of reduction or compromise.
Yes. Can I suggest that it's not referring to a settlement sum? Settlement at the beginning of clause 4 in my submission, is referring to the agreement we've seen in the preamble as well. We've reached a settlement.
No, it's referring to payment of the settled sum.
Yes, that's fine for my purposes as well. Payment of the settled sum, but it's not saying an amount of money shall be considered as full payment.
Well, 60,000 Saudi riyals.
Yes, payment of 60,000 or 60 million Saudi riyals. And what that first sentence is declaring is that that payment is full payment of the debt within a period of 60 days. In a nutshell, that's what this agreement is. It's providing for full payment in 60 days.
That much, I think, must be uncontroversial.
Well, I hope so, except that there's a temptation, I think, on the defendant's side to read in to the first sentence here, well, it'll be full payment if it's made in 60 days. So that clause 4 at the beginning is bringing with it this idea of conditionality.
Well, no, the conditionality is in the second clause.
Yes.
Second sentence.
So first sentence is setting out the discount.
Is the nutshell
right?
of what this agreement
and
is.
the second one is what happens if you don't fail to, and you can make a fair point about the word fail, but fail to appear to the timetable agreed upon. And then you've got the quid pro quo. Then if you don't pay, you lose the settlement.
Well, exactly. So then we come back to the central point. What does it mean to say it's null and void? Do we follow it? Does it mean what some of the cases have said, void at the option of the innocent party, or does it mean automatically void?
But what this is all about, it seems to me, is that there's a quite straightforward settlement. And just going back to your heading point, it seems to me that full clearance, so final clearance agreement means no more than final settlement agreement, doesn't it?
They're probably interchangeable, although clearance gives you the idea of getting rid of the debts.
Or final clearance and final settlement and provisions relating to its.
Yes, there may not be much difference, but you wouldn't expect. Sorry,
but the difficulty here is that it seems there's no difficulty with the pattern my lord put to you, which I think was very much along the lines that I was putting to you before, works perfectly sensibly. What you need to add into it is the concept that if the sum isn't paid, the defendant remains personally liable for the 60 million, and that is what is the surprising element, which you seek to draw, and you derive it simply from the wording of clause 6.
Yes, can I take it in two stages? So I do say the outcome is that the defendant remains personally liable, but the first stage is whether the day after entry into the agreement he's personally liable. And the second stage is whether the end of clause 4 means the agreement falls away automatically. If you're with me that the day after entry into the FCA, he is under an obligation to pay, then it's not surprising to find that as long as the FCA is on foot, he remains under that.
I understand that, but that's the big question.
Exactly. So that's the big question.
This all comes down to one question at this point. Is this an agreement whereby the defendant accepts a personal liability for debts that are not his, or is it an agreement which gives him the option of discharging his company's and father's debts at a discount?
Yes, and the word option is obviously one that you don't find anywhere in the FCA, nor the idea of a right but no obligation. So I entirely agree with you. That is the nub of it. It was put to me that I was reading in the words void at the option of. Exactly the same thing could be said against me. Could be said by me against the defendant when it comes to clause 6.
Yes, exactly. The point goes both ways.
It goes
so
both
it's a
ways.
question of objective construction.
Yes. Can I pick up one reference to pledges that we haven't looked at yet?
Yes.
Just to show you it is a word that's intended to have some force, and that's clause 8.
Yes.
What is said there is that my clients, together the first party, pledges to hand over to the second party the notes corresponding to his payments, provided the notes are handed over upon full payment. That's not a word in that context, or in the context of the FCA, that means he has an option. We have a choice about handing over the notes. That's nonsensical.
What does it mean by corresponding to his payments?
Given that the rest of the sentence means that all notes are handed over upon full payment of the amount agreed upon,
Suggests that you hand them over as you go along.
well, I wondered about that, but no, that conflicts with the rest of the sentence.
And also, I don't understand under clause 6. Can you help me? Why does how are the amounts paid allocated as between the claimants?
I think the answer to that is it would be left up to the claimants. There's nothing in this agreement, but then there perhaps needn't be, that says as between the claimants how these amounts are going to be allocated, rather like as between the defendant and the other companies and perhaps his father.
But you do, but forgive me, I'm not sure that can be right there, because clause 11 provides that that if the amounts paid to the first claimant exceed the amount due to him, then this clause has effect, doesn't it?
Clause 11, is that?
Clause 11. So if he's paid 51, if he's paid 51,500, then doesn't clause 11 have effect vis-a-vis him?
So you're looking, my lord, at the last sentence of clause 11. Complete release should be provided by the final clearance statement.
Yes.
Sent by him as he's received all of his rights. I don't read him having separate rights under this agreement. It's rights agreed upon in this agreement. So in my submission, what that's saying is there's to be a complete release proved by a final clearance statement.
Well, I think that's quite difficult in the light of clause 3.2, isn't it? Might claim that it's settled 51 million due to him. Anyway, well, that may just be a...
That would be a right outside the agreement, though, clause 3.2.
What do you say about the adequacy of this document?
I'm not going to lead with a chin and say it's a perfect document, obviously. But what I am going to say is that the context, well, the tools of interpretation that we've looked at and we're going to come on to do disclose clearly two things. One is an obligation on the defendant to pay. And the other is that if you read the end of clause 4 in the context of the factual matrix and with an eye to the commercially sensible construction, it does mean,
We've
in the
looked,
case
at
of
four, we've looked at 4 and 6 in some detail.
yes. Is there anything else?
Do we need to look at the factual matrix now?
Can I check whether there's any other clause I should show you? So 8 we've looked at. 2 and 3 we've looked at. Clause 7, we were shown the opening words, once the settlement amount has been paid in full. And I would pause there and say, if this were an option agreement, that word would be if the settlement amount of 60 million is paid.
And that just balances out clause 10, doesn't it? You can make point that once, if, upon, in the event.
Yes, there's another difficulty with clause 10, which is the words hereby terminates, if you weren't shown, as opposed to terminating on payment in full, is what we're seeing in clause 10, a statement that while the FCA is on foot, you can't pursue the hospital or the father or SAR trading. So it's a sort of classic settlement agreement that says, while this agreement's on foot, don't pursue for the underlying liability.
Goodness me, that's what you think clause 10 says?
No, but the words hereby terminates suggests termination at the beginning. But then, when you look at
I
clause
just
11...
can't understand clause 10, the first sentence. Was there a contractual relationship between the second party and...
There was, yes. So
Right.
contractual relation between the second party and the first party, either the legal services contract or the promissory notes.
Well, sorry, the second party wasn't a party to the promissory notes.
The hospital was a guarantor.
The hospital...
Sorry?
Yes. The second party includes the hospital.
But
Well,
The
no, it doesn't.
doesn't
Well, I
have
suppose it
own-
depends whether you read second party in the way the preamble does, which means obviously the son, it's referring to the father, or whether you read it in the way that just the definition of the party.
Well, the definition of the party says in his personal capacity and in his capacity as director. It's not saying that the party is the Sard Hospital. It's just saying he wears two hats. So I've never thought it was suggested that the hospital was actually a party to this.
No, you're right.
Well, I don't know. I mean, I think if that's not the case, then what's the purpose of clause 12?
That's where I was going, because that's the power of attorney.
There's no. There's been. Is there? Do you suggest that under this agreement, Sard Hospital pledged to pay the discounted sum and was thereby released when Sard Hospital was fully on the hook for under the promissory notes as guarantor? So that can't work.
Well, it could do. It could certainly be that pre-existing creditor-debtor relationship. Debtor says, I can pay you now. Creditor says, fine, let's enter into an agreement. I'll accept 16 million in full.
That is the
final
purpose
settlement.
of the agreement, isn't it? Is that they pay 60 million and all the promissory notes are released.
Yes.
Well, and as I understood it, it's the second party has the opportunity. I won't use the word option because that's a legal concept. The opportunity to make payments in accordance of a reduced amount in accordance with a scheduled timetable. If he does, clause 8 says he is given by the first party the notes, the promissory notes corresponding to his payments. There's an interesting question as to if he paid the equivalent of 27 million riyads, can he actually ask for the first note to be, or the notes amounting to that amount to be handed over? There were two notes, weren't there?
Actually, there are 8. altogether.
Yes, but
2 for him.
2 for him, yes.
yes.
It's the same tab. Sorry.
Yes. But the point being that he then gets the promissory notes into his hands. So, in other words, they won't be capable of being enforced. So, effectively, that's discharge of the promissory notes, or at least it would allow him to, potentially under Saudi law, who knows, to claim as assignee, transferee, or just have a right of subrogation. But the point is they wouldn't be capable of being enforced by your client because you've handed them over.
Exactly, yes. Although the second party on any analysis includes the father. So it's not quite as simple as...
Why do you say
Son.
that?
Uh,
On behalf of his father.
exactly.
Although the recital treats his father as, in a sense, not a party, not within the definition of the second party, because it talks about the second party's father.
Yes.
Um,
Yes, exactly.
and to be fair, and at this stage, the father was in prison anyway.
Yes.
So it's unlikely, actually, that he would have been receiving a visit with a promissory note to be handed over to him in prison. I mean, it's pretty clear, isn't it, that the handing over would be to Mr. Michal Marnand Al-Sanea.
Yes, I'm sure that's the likely route.
I mean, the wording, the body of the contract is entirely inconsistent with the father being a party. Time and time again. Second party and his father, etc., etc., etc. What does the signature help us? Is it just the names?
It seems to be just the names, I'm
Right.
afraid.
Okay.
Clause 12 would indicate that it is important he has a power of attorney for his father.
Can I ask this? If none of the settlement monies are paid,
None are, yes.
so there's a debt owed to your clients of 91 million. None of them are paid to you. Why would your clients want to maintain an agreement, a settlement agreement, where they would accept 60 million from Sard Hospital?
Only if there's a dispute as to whether that really is the sum owed. I think it's not going to work so much for Sard Hospital because that's under the promissory notes, but against the father, and then it's just debts under the legal services contract, there may well be an advantage in pointing to the FCA and
But
saying,
forgive me, but your argument is that your clients would have the right, if no payment is made, to maintain the settlement to 60 million against, and it would be against, and the second party includes the hospital and the father.
I don't think
commercial sense.
There's no advantage in pursuing the father or the hospital, save perhaps for some argument that because this agreement declares the agreement's been fully executed, it removes that issue. The commercial sense would be to pursue the defendant. And that's why he is a party to it, he's on the hook, and that's why he undertakes an obligation under it.
So, sorry, I'm not sure I follow that. If he doesn't make a payment in accord, if the second party, the defendant, doesn't make payment in accordance with the schedule,
yes.
If your clients were to say, okay, this agreement will remain on foot, and you can bring proceedings against the second defendant for 60 million Saudi riyals, $16 million.
Yes.
Then, if he says, or if that's fought and whatever there's a judgment, and then he pays, you wouldn't be able to go against the companies for the balance.
No, I agree. Absolutely, I agree. Because then it would be payment under the FCA, and all the consequences of payment under the FCA would follow. I think what my lord was putting to me was, well, what's the advantage in having an obligation on the part of either hospital?
Your construction, I think the point is that your construction entails that not only will the defendant remain on the hook for the 60 million, but the principal debtors will still maintain the benefit of the settlement agreement in perpetuity.
Well, I'm not pressing the construction that the parties to this, either the essential operative parties, are other than the defendant. This is an agreement that obviously follows a number of promises by defendant and is saying, okay, we're going to memorialise your promises to pay. So obviously what this is intended to do is achieve payment by the defendant of the sum that he said he's going to pay.
Well, then why does it say in his capacity as Sard director and on behalf of his father?
And that, in my submission, would allow both of those parties to rely on the agreement if payment is made and say, well, we've got no further liability.
But they'll be able to rely on it even if payment isn't.
But if payment Well, if payment isn't
If
made,
you don't,
and
if you choose not to void the
yes, if we don't void
contract,
it, then we're only suing the son for the 16 million, and if that's paid, then the consequences follow under the FCA. If we do avoid it, then it would be, we'll put that to one side,
yes,
and sue them under the promissory notes or the legal services contract. So it's saying, as against the defendant, this is an additional point. You've made promises to pay, we're going to turn that into a written document. So I think that does take us then to factual matrix, my lord. And there are 5 elements here.
So have you answered the what happens if some payments are made but not others?
Oh, so in our submission, if some payments are made and not others, and then the agreement is void, and I agree with Milady that this is a consequence that runs either way. If the agreement's void as a result of our option, or if it's void automatically, those payments have to be returned. They are payments made under a void contract. Now, the big difference between the constructions is that the creditor is entitled to choose on my construction. The creditor is entitled to say, no, I don't want to have to repay these. In effect, the defendant's construction turns the claimants into a bank, because the first 2 payments might be made, $8 million US. The final payment is then missed. The claimants can't do anything with the money until the 60 days is up, or 56, and we know whether the final payment's made. And at that point, on the defendant's analysis, the whole agreement is void and the money has to be repaid.
I'm not sure that's right at all, that the money has to be repaid.
Well, that would depend, my lady, on the fact that, or the idea that running in parallel with the FCA was an enforceable obligation, either under the promissory notes or the legal services contract or something else.
but there was.
And
There was a parallel, this wasn't extinguishing the liability under the PNs, was it?
well, there are 2, well, there's one answer to that, which is the sort of common sense argument that it's a settlement agreement, he undertakes liability to pay. While that agreement is on foot, if the creditor then goes for the higher sum, you'd think the other debtors would be able to say, hold on, we've settled. That's the effect of clause 3. Now, I agree if the agreement's void for non-payment, then that falls away. But while that settlement agreement, while clause 3 is in force, they can't pursue other parties for the higher sum. That's the very reason why, on Miller and Friends analysis, you have the second sentence of clause 4. And the other clue, perhaps, to that is this suggestion that this agreement is terminating, while it's on foot, other relationships. But I think the first point, which is there is a settlement, there is an agreed settlement sum, is enough for our purposes. So it's clause 3 that I say achieves that. And I do say then that the payment would be made under a void contract.
But if that may be right, but being paid under a void contract isn't the end of the matter. If there was a pre-existing liability, the payment to discharge, and there was.
But if the payment wasn't made to discharge that pre-existing liability, the payment is specifically made under this agreement, and it's then void ab initio.
Well, it's a payment. It's a payment towards the liabilities of Sard Hospital and Mr. Al-Sanea Senior to these claimants, and it's paid by them. I think it's very difficult to say that there'll be a right to restitution of those sums.
What if it wasn't paid by them, my lord? What if it was paid by the defendant?
But we know it's paid by the second party. Whoever actually pays it is paid on behalf of the second party.
And that then leads you right back to the question about, well, who's actually undertaking an obligation to pay? And obviously, in our case, there is an obligation to pay.
Well, we know it's the defendant in his three capacities.
That, I think, is an answer that I'm happy with, because the defendant in his three capacities is accepting an obligation to pay. So the defendant in his personal capacity is accepting an obligation to pay here.
Well,
if the second party is accepting an obligation to pay under this agreement, then that's
leaving us. Well, certainly, it seems to me there's no reason why those parties who owe the money can't be under an obligation to pay, or sorry, we're talking about obligation now. We're talking about who is it who is paying. That's the question on the obligation. We know that two of the parties whom he is acting on behalf of do actually owe this money to the claimants.
yes. So if those parties were to make the payment, then there might be a different analysis. But if the defendant makes the payment under an agreement that's void, what then happens? Is the creditor entitled to treat that?
Well, that may be something that would have to come out in the wash. It may be a matter of Saudi law as well.
Yes, but the fact it's a...
But as you say, it was something which will an issue which would arise if your clients
declare it void.
declare it void.
But that does suggest that the creditor should have the ability to choose whether it's going to be void, and so all of these difficult issues arise, or whether to maintain it on foot.
Well, the creditors may not know who's paid what, or in what capacity, in terms of it influencing his decision whether or not to void.
Well, then it may be a question of having to find out, but again, that's another layer of uncertainty which is resolved if the proper construction of Clause 4 is to say it's void at the option of the creditor. So in terms of factual matrix, which is where I was going to go next,
Yes.
I was going to address 5 parts to this. Firstly, the debts. Secondly, the relationship. Thirdly, promises to pay. Fourthly, means to pay. And fifthly, the acceptance of possible personal liability. Now, the debts, I think you have the point that these are long outstanding, high-value debts that have been chased for years. In the judgment at paragraph 34, there's a reference to a letter of September 2015 where SAR Trading declares the amount it owes as 50 million SARs. And paragraph 41 of the judgment refers to the October 16 retainer that you saw as imposing a liability for a further 30 million SARs.
Sorry, paragraphs.
It's 34 for the September 15 agreement. And in your core bundle,
Yes, I've got that. And the other paragraph.
56, and then the
Thank
other
you.
paragraph, 41.
That point can only take you so far.
Oh yes, but in terms of the amount that's already owing before the FCA, and when we come to promises to pay, how much is being promised? The amount outstanding, the size of these debts, does support the idea that one's entitled to look at this FCA and say, this is intending to clear it. We're not dealing with some minor debt that hasn't been outstanding for years. On the contrary.
Go around in circles there. I mean, there's no doubt that this was intended to clear. The declared intention in here is that 60 million be paid in instalments, and that would be full and final settlement.
And if that's right, then the idea that it's an option, so it's just at the whim of the defendant, there's no certainty at all, runs counter, I say, to the idea that there's supposed to be certainty.
But, well, never mind. I think we're slightly going in circles.
The high value debts.
So high value
for a long
debts.
time. Yep.
Secondly, relationship. It's coming to an end. So we know the retainer's been terminated. We know the evidence on the defendant's side is of distrust. And we know that he told the claimants he wanted to finish it up with the claimants' fees.
And the reference for that, please.
That is paragraph 375 of his witness statement.
No, finding of the judge.
Judgment 114 is in relation to the stage they're at. The distrust is...
No, sorry, just the finding that Mr. Al-Sanea said he wanted to finish it.
It's not in the judgment, it's only in his witness statement.
The reference to the witness statement
Is S, so supplemental bundle, tab 5, page 173. It's paragraph 375. The third part of the matrix is the repeated promises of payment. So we leave to one side subjective intention, which, as the judge found, was never to pay. But instead, we focus on the communications crossing the line. And those are repeated promises by D to pay, sometimes using family assets, the jewellery. Mm-hmm. And in the judgment, you see paragraph 108 and following, under the heading of Defendant's Ruses, Claimants' Pressure and Defendant's Ruses, July to November 2017. The first paragraph, 108, there is the jewellery point.
I'm nervous about this, simply because there's so much detail, and who thought what at the time. And we certainly weren't taking things at face value in terms of what was said. So you weren't, no criticism, you weren't there below, were you?
No, neither of us were there below.
Yeah, so we know that there were significant departures from the witness statements, certainly by Mr. Al-Sanea.
Yes.
That's in the face of the judgment.
Yes.
We're sure, are we, that there's nothing in the cross-examination or anything else that undermines reliance on witness statements or paragraphs in it?
Well, this particular point, I can tell you there was a departure in the oral evidence. Yes. Because paragraph 108 recites it.
Yes.
But
these are all non-binding promises to pay, aren't they?
That's right.
And I'm not sure if that really helps you, because I mean, if you've got a whole pattern of non-binding promises to pay, it could be said, well, this is just another non-binding promise to pay.
It could be, but what would be the point then? Why an FCA that includes another non-binding promise to pay?
Because he's got the option of, he's got an option if he can get the money together of getting the whole thing discharged for 60 million.
Isn't the alternative? There have been a number of non-binding promises to pay. Mm-hmm. He asks for 60 days in effect and says, I want to pay. And the creditor's reaction to that is, right, let's document it now. If that's what you're telling me you can do, let's put it in a document, bind you to it, and there will be a consequence if you can't.
Well, that's what we have to construe.
And that's exactly.
I'm just not sure that anything you're telling us here helps on that.
Well, I suppose step one is it's consistent. My analysis is consistent with the number of non-binding promises to pay that come to nothing.
How does that help us in whether or not this is a binding promise?
So if you're construing the words of the FCA against the background of a number of non-binding promises to pay,
yes,
you're entitled to ask.
Your clients would have wanted a binding promise and the defendant would have wanted a non-binding promise.
Well, he'd given a number of non-binding promises. We come then to November 17. Sorry, my lord.
I mean, you keep on trying to... I mean, you characterise this as promises by the defendant to pay. I mean, I'm just looking at 108. I mean, he's not personally promising to pay. What he's doing is saying, I may be able to secure some money, you know, from other sources, from selling family jewellery. I mean, he's acting as a sort of family fixer, isn't he? He's not saying, I will accept personal liability, I will pay, and then not coming up with the money. He's just saying, I may be able to get some family jewellery together. In other words, interesting question about how he does it, but you can't really say that he's I think you said earlier, and I thought we were on common ground, that there was no sort of prior indication that he was going to accept personal liability for fees.
Yes. No, I agree with that.
So all he's actually done, I mean, it may just be that we're in an argument, loose use of language, but he's not personally promising to pay at any previous time.
He's not promising to pay with his own money. No, I agree with
Or
that.
accept personal liability.
Or accept personal liability.
So
he's saying, I can pay you. And the routes that he talks about differ.
yeah, I may be able to...
So it's just showing me where he says I can pay you.
So
I know I've read some WhatsApps about jewellery and stuff, but where does he say?
I think the point is he doesn't say, I will.
No, he doesn't say.
I think what he says is,
I can raise
I
money.
may be able to hunt around the family coffers and arrange for you to be paid.
Yes, whether that by accepting a loan from somebody else.
But it's a long way from him saying, I will personally put myself on the hook with my own resources to you.
Yes.
It's a very different thing from saying, I may be able to hunt around and find some money from somewhere, which may be, or, may belong to somebody else. He may just be acting as an intermediary, basically, for somebody else within the family who owns the jewellery, who is prepared to pay a debt with an arrangement behind the scenes.
Yes.
Nothing to do with him personally.
The question is, does with factual matrix, the question is whether or not this factual matrix is capable of helping us in construing the words. And I have to say, we're a long way from that with this sort of material.
Can I switch round then to something that you don't see in the factual matrix, which is any request for an option or a right to pay but no obligation? So what you see from July 17 onwards, there'll be money made available, but repeated ruses.
So is this your fourth point in the factual matrix?
That's right. Well, under the heading of promises to pay, what you don't see.
No, well, that's noted. Thank you.
Sorry, under the heading of promises to pay, you don't see the sort of option, I will have the right.
Well, the judge hasn't made any findings about what happened at the two meetings, do it? He rejected Mr. Al-Sanea's evidence that Dr. Al-Subaihi had said null and void.
Yes.
Other findings of fact in relation to these meetings, insofar as it's admissible, we don't have any, do we?
No, not at the meetings themselves.
We've just got the reduction in the fees and the date time that's been agreed.
Yes, the
payment.
period, exactly.
Yeah.
So the period changes from 30 to
Yeah.
60. The amount goes down by 34%.
Yes.
The next factual matrix point, one that Lady you raised, which is means to pay. And the learned friend took you to paragraph 112 of the judgment. Which was the quotation, the problem is no one can believe that you can't pay. And that was in support of a submission that everyone believed this wasn't a situation of can't pay, it was one of won't pay.
No discussion or finding about what you meant or anything like that?
No.
Is that it on that point? Is that it on that point?
From the judgment, you've got my point in the skeleton as to actually in terms of what do people believe.
No, there's well, the only thing you've taken us to, it's no criticism. You, just so I'm clear, you've taken us to one section in Mr. Al-Sanea's statement saying, I thought they believed I would be able to collect the money or get the money together.
Yes.
Thank you.
And that is, I say, consistent with the repeated promises beforehand, giving the impression that I would be able to get the money together. And it's consistent with the claimant's claimant's witness statement. It's para 112 and following, and it's the judgment at 114, talking about the need for a formal agreement. And what the judge says is the claimant's evidence wasn't they decided they needed a formal agreement dealing with settling of their debts. And that's taken from 112 and following, where the claimants say, just the first claimant in his witness statement, it's S468, that because of the promises to pay and indeed the imminence of the payment, they thought they needed a written agreement.
Yeah.
And finally, acceptance of personal liability. You raised, Milady, paragraph 89, the judgment. And as we say in the skeleton, one needs to distinguish between personal liability under the promissory notes and the possibility of liability if they were enforced at the court. JDEC is the special court set up for enforcement against the SARD companies. And both sides accepted, potentially under Saudi law, as a director of the hospital, the defendant could be personally liable through a signature of the promissory notes.
But was that ever referred to at the time?
Yes. So in both witness statements, you have a reference to that. Let me show you. So, the first claimant's witness statement is paragraph 124 on page 71 of the supplemental bundle, behind tab 4. Tab 4, page 71. It's the end of paragraph 124. But I need to show you also the defendant's witness. So end of 124 states the position. It's not an answer directly to, my lord, your question about exchanges crossing the line.
No.
For that, if you go on to the next tab, page 159, paragraph 322.
159.
159, paragraph 322. You should be in the defendant's witness statement. Paragraph 159, right at the bottom of that. Sorry, page 159, paragraph 322. It's the bottom of 159. And in the italics, third line, the message that goes from defendant to second claimant is, I wanted to ask you a small favour. Last week I was informed an order issued against me and my brother, like the father, because we're managers at the hospital. As you know, the matter harms me personally.
And what was the order?
And the order is the bench warrant we see from the first line of 322.
But what's that got to do with the promissory notes? I mean, the whole point was the promissory notes hadn't been put to JDEC. That was the threat.
No. So what I take from this is that because they're managers at the hospital, there's the potential
They could be liable for debts.
Well, wait a minute. There's an awful lot more going on to justify the bench warrant, isn't there? It's not about debts to your client.
It could be all sorts of business, ability to trade, etc., etc.
I mean, this was a massive insolvency in the jurisdiction, and the whole court was set up to deal with the consequences of it. I mean, the idea that this is indicating some concern about personal liability for the debts to your client.
I'm not saying it's anything about my client, but I'm saying the reference to being managers at the hospital as the reason why this is a problem
Is this any more than a version of the sort of liability that a director could be under in this country if they were engaged in trading whilst they suspected a company was insolvent?
I'm not sure I can help you with what they feared under Saudi law.
Well, do we know that it's any more than that? I mean, is there anything which would suggest that the liability of a director for a company's debts is any more than the sort of liability which could arise in this country under our law?
Whilst Mr. Robinson continues to ably respond, could I just ask everybody to check, is there any reference to this email in the judgment? Anything that can help me? You carry on, Mr. Robinson.
I was going to take you back to the end of paragraph 124
Yeah.
Okay.
of my
Give me the
findings
reference.
on page
14th of
71.
August.
$171.
So page 71,
71.
paragraph 124. So it's back to the paragraph we were just
Yes.
looking at.
Yes.
I think that's the best I can do, because what it says is that failure to honour promissory notes is a serious offence and liability is automatic. As a director, you could potentially be personally liable if there was enforcement against the hospital's guarantor.
But what there is not, as I understand it, is you cannot point to anywhere, any evidence that your client any time said to the defendant that he was in any event liable personally on these promissory notes.
No, I can point you to the judge's finding that there was a potential for liability.
Yeah, that's paragraph 89.
Exactly, paragraph
But
89.
that's not.
But I can't. Exactly,
That's
I can't
very
point
fair.
you.
This wasn't a situation where you were saying to the defendant, "Look, you're on the hook for these debts personally, so you better come up with a proposal to pay them." I mean, that's the sort of seems to be factual matrix which might be relevant. If you were saying to him, "Look, you're going to be on the hook for this eventually, so you better settle with us personally."
I'm just going to take you to why the judge says that the FCA doesn't fall, or it is to the benefit of both parties. So
Yes, that's a
193 and 194 of the judgment. Actually, you probably want to, you may need to start at 192. So under the heading of undue influence, he's talking about whether the FCA needs an explanation.
and it's definitely not in there because we would all have picked it up. So it's really, the meat of it is, you know, in the grand scheme of things, families' overall interests and what have you. Reduction in the debts, etc., etc. Fortunes bound up with those of his father. But there's nothing about a threat or a concern about personal liability as director under the promissory note.
Not at the time, no. He talks about the potential benefit. But no, not saying in the run-up to the FCA there is a threat to pursue
Or even evidence of an understanding on the part of Mr. Al-Sanea that there was a real risk of personal liability as guarantor under the PNs.
Have we covered personal liability? Yes. And number 3 is commercially sensible construction. Have we pretty much covered that in argument? Or is there any more to say about that?
I'm keen to give everyone a break, so it may be that if there's anything else I want to say,
Shall we break now?
Break, and then if there is anything else, I'll make it as quick as I can.
Yes.
Depends whether now is a convenient moment to.
It is, thank you. We'll have a 5-minute break now. Perhaps you can think about that during that 5 minutes.
Lady, we were just before the break looking at the judgment for the point about personal liability. The other paragraph, just for your note, although it doesn't take matters a great deal further forward, is where the judge is dealing with the fiduciary duty point, and it's paragraph 177 on page 85, top of page 85 of the core bundle. So
Oh, yes.
this is going through the various reasons, and you see the sentence, there was also to be avoided the potential disbenefit.
Yep.
So nothing to say when that was apparent to the parties, but it's recorded there at 177 as well.
Thank you.
Commercial common sense, and two additional points I wanted to pick up under this heading that we haven't covered. One is to look at the defendant's skeleton argument, but the other to start with is to stand back and say that what the defendant's construction means is that the parties have negotiated both a 34% discount in the fees and an increase in the time to pay. And we know that's taken at least a month in November. And we know there are other amendments that have been discussed. You have that in the judgment, paragraph 117. All of that hard-nosed negotiation on the defendant's concession was in fact leading to an agreement where the defendant has no obligation at all, and 7 days after the FCA is entered into, the defendant can choose to avoid it altogether. So the first payment is due 7 days after the FCA. And we do say that is commercially extremely surprising, that if parties have negotiated an extension of the time to pay, 30 to 60, and have gone through the back and forth of the extent of the settlement sum and landed on 34%, the settlement agreement...
Forgive me, I find that surprising because over and over again you see agreements where creditors, say banks, agree to accept a particular sum by a particular date, whereby they'll take less and they'll give more time. But on terms that if it's not paid, the full sum is due and payable.
But you wouldn't expect in that agreement the structure of it to be simply an option. So certainly the bank would agree to accept a certain amount in a particular time.
But that then takes us back to the key question.
It does, but it's an indication if there's been this month-long commercial negotiation and hard-nosed...
But a month, when we're talking about that negotiation ending up with parties agreeing a 34% discount,
Yes.
that's something that's worth negotiating over. I mean, as I understand it, it started off as less than that.
That's right. Starts off at 50.
So I don't really see why hard-fought negotiation, and this is where they got to, rules out either construction. They're both consistent with the parties having reached this agreement. As we discussed, the only difference it makes on the two constructions is whether or not you have the defendant on the hook.
Yes, absolutely. But it would be very surprising in my submission, having gone through the efforts and having reached that negotiated conclusion, the effect of what you've agreed is that 7 days later, the whim of the debtor means the whole thing is null and void and ripped up.
It's not the debtor.
So under the agreement, sorry, the promising party. If I
But that's the whole question.
take the question. That's part of the question. So the defendant, if I put it in neutral terms, at the whim of the defendant, 7 days after they've entered into the FCA, it's ripped up and the parties are back to where they started.
Yes, but I think that's the... I think that's the key distinction, isn't it? I mean, here you have somebody who is not a debtor.
Before the FCA, I agree.
Before the FCA. On the face of it, the creditor is not obliged to accept payment from anybody other than a debtor. You know, creditor can perfectly well say to a third party, who are you? You're not my debtor. I don't have to accept money from you at all. Here's an agreement where the family affairs are in chaos. Well, hang on. Father's in prison. There's clearly something going on badly awry with the companies because of the financial crisis, da-da-da-da-da.
Yes, we know that the hospital is anticipated at least a month before to be able to avoid liquidation, and liquidation doesn't
Yeah,
happen.
okay, that's hard. Again,
But yes, I'm not going to quibble over the family finances are in difficulty.
they're in, okay, whatever. So, in those circumstances, I don't see it as bizarre that the creditor would say, okay, look, if Mr. X, if you can come up with money from whatever source we won't inquire too closely, we'll enter into an agreement that if you pay us X, or you arrange for us to be paid X, who knows where you're going to get it from.
Yes.
You are the director of one of the companies, you seem to have some relationship with another one, you're the son of the father. If you can come up in one way, shape or form with this amount of money, we'll be happy, delirious in fact. We'll hand you the promissory notes, which otherwise we've been threatening to lodge at court, which will definitely bring the house of cards tumbling down, I think. Everybody would anticipate. And we'll enter into all sorts of agreements that make it clear we're not going to go after your father or anybody else for the balance. There it is. Take it or leave it. If you can pull it off, great. But if you can't, we're back where we were. This is your final chance.
Well,
if you want to do right by your family, do it this way. I mean, why is that? I'm struggling to understand at the moment why this is so commercially bizarre. That that in a sense it's an offer, it's an opportunity. Why does it not make sense without a personal obligation?
Well, there are two answers to that. One is just the point that I was making about the FCA itself being a carefully constructed deal, if you like, the 34% the time to pay. There's another answer, or more identifiable with your point, which is, hang on a second, if son comes along and says, I can do something about this, creditor would be delirious. The answer to that point is, well, you wouldn't need any agreement at all. What would then be happening?
Well, yes, you would if the son isn't a debtor, because on the face of it, all sorts of problems arise when you start accepting money from a Mr. X. Or discharge of debts. You don't. You need to do something about papering that agreement, and he certainly would want it papered if he's getting money in, not to put himself under an obligation, but so that he can secure, first of all, delivery up of the promissory notes, and the discharges which benefit people who aren't actually parties to this agreement at all, but who he's interested in protecting. I don't think they are parties. I have to say, I'm afraid this agreement reads, the second party reads as if it's him personally. I mean, I know it's said it's dealing in certain capacities, but
the focus is obviously on him. Absolutely right.
Yeah.
And that's what makes the difference, if you like, from pre-FCA to post-FCA.
Yeah.
It's his personal position, which leads me back to the point that actually he is undertaking an obligation. But to your point, does he need to undertake an obligation to have the ability to make that payment? Why would the creditor then not say, well, look, the hospital owes us. We can do a deal. If you want, on behalf of the hospital, to pay less and pay it soon, we can do that, that's fine. But given it's the defendant who's been making these representations, if you like, from July at least onwards, given that he's the point of contact, and given that we know he is a party to the FCA, I say that you read Clause 6 and the pledge to pay as being an obligation.
Yeah,
Now, if it didn't say that, if it said something like, you've got the option...
But in economic terms, what he's doing is he's buying the debt. I mean, if he was interested in it for some other reason, he's basically buying the debt that is owed by the father and the companies, whatever, to your clients. He's buying it for a reduced amount if he can pay the reduced, or cobble together the money in a reduced amount. You don't care, as long as you get the money within a certain time scale. And then you make over to him all the promissory notes, etc., and release the debtors. You have no idea what he's doing behind the scenes, what arrangements he's making with the debtors. But in essence, he's got an opportunity to buy the debt from you to save you enforcing it against his family.
But aren't there two quite distinct differences, quite distinct points there? One is agreeing to buy the debt, and the other is having the opportunity to buy the debt. The FCA doesn't read.
But neither way, in neither scenario does he take on an obligation to you.
Well, if he agrees to buy the debt. So if the way of reading the FCA is we have a settlement sum under Clause 3, we've settled for this amount of money, and the FCA then says, pay us that amount of money and we'll give the notes back.
Yeah, but then you wouldn't put everything's null and void at the end, would you?
Well, and that takes us right back to Clause 4.
Which is where we sort of come into this. But
yes, so I think what I'm putting to you, well, the way around, what you're putting to me is a suggestion that defendant is interested in buying these debts.
Yeah.
And my answer to that is, well, yes, that may well be right, but the way in which he does that and the terms on which he does that take you back to the FCA terms. Is he buying them by means of accepting an obligation to pay, or is he buying them in the sense that he wants an opportunity to buy them later on?
Yeah.
Which brings us back to, what does Clause 6 actually say? From the moment the FCA is entered into, is he accepting an obligation to pay money in return for these debts or for notes? Or is he just simply having an opportunity?
But why would you put the null and void wording into clause 4 at all?
Well,
In that
sort
of scenario.
from the creditor's perspective, you would want an agreement that puts him on the hook and the ability to keep him on the hook. What you want then is, here is the defendant saying, I'm going to buy the debts. I agree to buy the debts for 16 million. You want the ability to enforce that. So what you want is, obviously this is my scenario, void at the option of. That's what the wording
Can I
is.
ask a different question?
But
You're gone. Sorry.
I'm briefly going to come back, because what you then want is the ability to go back.
Okay, so maybe the analysis, you say it cuts both ways.
Yes.
Okay.
Yes.
The
Go back against the primary debt.
judgment records that it was common ground, at least by trial, that English law would be applied, would be applicable to these claims.
It does.
How did that come about? Can you just help me with that?
I don't know how that came about. We've all
Because when we're
seen
looking
them.
at objective interpretation, I mean, we aren't in a position to know, but we have no idea whether there's any equivalent canon of construction as a matter of Saudi law.
No, that's right, and you see reference in some of the amendment discussion at
Yeah.
the end about expert evidence and it falling away because parties are...
Right, okay.
I can't help you with why. It occurred to me also that obviously we're dealing with a translation.
Yep.
And so you can't take the words null and void as bringing with them a whole baggage that under English law they might have. We don't know what words in Arabic the parties have chosen. So none of this is entirely satisfactory.
Or pledge.
Or pledge,
Yep.
On both sides.
Mhm.
Does that drive you then to look at the underlying context and the sort of common sense, quote common sense, given interesting your frame of references, but at least does it indicate that we should be rather more concerned perhaps about context in this rather unusual scenario rather than the words which the parties have used, given that these may not be the actual words they've used?
I think it takes you to being very cautious just looking at parts of the contract. So it would be wrong to, for example, just look at the end of clause 4 on its own.
Yeah.
Even probably wrong to just look at clause 4 and 6 together. If you look at the whole of the contract, and then, yes, perhaps it is a circumstance where the factual matrix, the commercial common sense approach has a bit more weight as identifying the proper interpretation. And certainly we would say, for example, the title, as I've already said, bears some weight supporting our analysis that what we're looking for here is finality, and what you don't get on the defendant's construction is finality. I said I would pick up the points against me in the defendant's skeleton argument. It's paragraph 34, 33 and 34, which you have in the core bundle, behind tab 2. Because both sides recognise, obviously, the need to put forward a commercially sensible construction here. So paragraph 33 and 34, it's page 28 of the core bundle. And paragraph 34 starts, this is the only interpretation that even begins to make commercial sense. And what that's referring to is the end of 33. That there's no indication from the wording of the FCA clause 6 is to be prioritised above clause 4. They're to be read together. When this is done, the meaning is clear. I want to come back to that point. Then, if payment's not made in accordance with the schedule, D loses the right to discharge. And then into paragraph 34, you've firstly got the point about D's evidence that he didn't have the resources to pay. It's not said, rightly, that that is evidence that crossed the line. And then it is said that the commercial sense is the parties enter into an agreement, gave D the right, not the obligation, to discharge the debts for a reduced amount. D could discharge the debts for less. And then equally for C's, last 3 lines, they were swapping their entitlement to the full debts in exchange for a possible swift payment without compromising rights against the original debtors. And so the 2 points to come back on then, firstly in 33, reading the 2 clauses together, 4 and 6. And I've made my point that clause 4 does refer to failing to adhere.
But this isn't a commercial common sense point, that's a construction point. 34 is the only commercial, isn't it? That's
Yes, sorry,
that's where we are now.
Yeah, so what is referred 34 is saying the only interpretation that begins to make commercial sense is the one given in 33.
Yeah.
And then the second point is at the end of 34, it's said to be commercial common sense for Cs to swap their entitlement to the full debts in exchange for a possible swift payment. And the key word there is possible. Because they're giving up their entitlement in return for a payment that might never come.
No.
No.
Well, they're swapping.
No, they only give up their rights
If it's
the
paid
payment comes.
quickly.
If the payment doesn't come,
Yeah,
they're
so,
back
yes.
to where they were. So they're not.
This is a shot to nothing for the claimants, isn't it? There's the possibility here that they'll get 60 million. If they don't, they're where they were with their claim for 91 million.
Assuming they declare that it's void or it's automatically void, they're back where they started.
Yeah.
But they're back where they started in a situation that's been endless promises not met.
That's why it's worth their while.
Lack of certainty.
Go.
Yeah.
Well, but that doesn't achieve finality or certainty. What that gives is the possibility.
No, but it will do if it's honoured.
If it's honoured, yes.
Well, I
but
think
there's
there's
no way
an
of
awful
enforcing
lot
it.
of weight on that heading to the agreement, and that, which in itself isn't described as being a term of the agreement. So, I think we've got the point on.
You've got the point of finals. You've got then the point, I would say, settlement
Yes.
and the wording of clause 6.
Yes. So is that commercial sensible construction?
Yes, because we've covered the other point about circumstances if on the way through.
And you've also covered before whether clause 6 imposes an obligation.
Yes, I have. Yes, I wasn't going to say anything more about that.
And then is the agreement automatically void? We've also covered as well, haven't we?
Yes, the only points there that are taken against me, one is the canon of construction of contra proferentem, and perhaps just for your note, Lewis and Paris 7.83 and 7.93 is the one suggesting some caution before relying on that. And
On contra proferentem.
On contra proferentem.
Yeah.
And indeed suggesting that it's not only contra the offeror, but it's contra the party that the clause benefits. So I'm not sure it's really, as a canon of construction, going to get you home. The cases, the only one I was particularly going to show you is Kerium. We looked at, or I described to you, the key ones, Chale and Gillenhammer. I think where one ends up on Gillenhammer let me make my submission on Chale and Gillenhammer. What was said about Chale, and that was the trade union case, is that Lord Diplock said that if the only circumstance where the clause operates, the clause for voidness operates, is a breach, then that's a strong indication of the party's intention that the contractual rights are those specified in the agreement. What Chale is all about is a breach of a duty owed to a stranger to the contract. And it's tab 14.
Yeah, it's the Bridlington Principles.
Exactly, Bridlington Principles are owed to other trade unions.
Yeah.
Bridlington Principles are not owed to members.
No. So no duty, it's not a relevant duty to Mr. Cheel.
Correct. And Mr. Shield therefore can't rely on the principle.
Yeah.
And that inability to rely on the principle feeds through then into Gillenhammer, because one of the reasons that the judge in Gillenhammer finds for, I may say, call it this, finds for voidness, as well as construing Article 23 and the opening words to that article, and a lot of weight is put on the fact it's subject to entry into force. But one of the reasons is that condition A and C weren't met. And what the judge says is that general rule doesn't apply because those are conditions that only come into force. Sorry, the voidness only comes into force because there's breach of a primary obligation. And that's not wrong.
Sorry, go on. Yes.
You can say that's not what Shiel says at all.
Sorry, you're saying Gillenhammer is wrong?
Well, the wording that you were looking at the top of page Authorities Bundle 558, tab 18, page 416 of the report.
So which bundle? It's bundle 3, isn't it?
I've consolidated them into 2, which isn't very helpful.
So 2. Bundle 2, isn't it?
Maybe
bundle 1.
Which tab was it?
18.
Tab 18.
That's
That's
2.
bundle 2.
It's a 1989 case, if that helps you.
Yep, here it is.
And we were looking at page 416 of the report, which is page 558 of the bundle. And my lady, as you identified, these are the actual reasons for the decision. They start on the left-hand column with a reference to the factual background. Then you've got the title to Article 23 and its opening 5 words. Then you've got, and I do place some weight on this, the point, middle of the left-hand column. Mr. Sumption's construction would be much more difficult to sustain if the clause had application after a stage at which either side would have embarked on substantial commitments. And that is the FCA, because this clause is said to operate for missing, for example, the third of the timetable to payments. And then at the top of the right-hand column,
It's completely my fault. I can't work out what it is. It's A and C could not operate in the absence of a breach by the party concerned. Can you?
well, rather like my friend A, if you go back to page 407 of the report, bottom right-hand corner gives you Article 23.
Yeah.
The first, so condition A, the builder declaring by telex
To the
buyer and the bank that the letter of guarantee as provided for in Article 15.2 of the contract has been obtained. And Article 15.2, same page, left-hand side. Well, Article 15 starts with default by the builder.
I see.
And then 15.2 is the obligation. The builder agrees to provide the buyer with a bank guarantee. And he's guaranteeing the refund under paragraph 1, which is a refund for sums payable or paid in the event that there was a default. So I think the point that's being picked up at 416 is that clause or condition A, i.e. non-provision of a letter of guarantee, automatically must entail a breach of a primary obligation, because 15.2 imposes a primary obligation. And the same could be said about condition C.
These are obligations under the contract, which are also conditions subsequent, I suppose, aren't they? Or conditions either precedent or subsequent.
When one reads Article 23 as a whole, yes, exactly. So it's not surprising, I say, that where the court in Gillenhammer comes out is that the proper construction of Article 23 is that the contract is void when they're not complied with. Whether you call them breaches of primary obligations or conditions may not matter very much, but the effect of not being able to provide a bank guarantee is to bring the contract to an end. That's what the parties have agreed.
But they're plainly conditioned. This contract is subject to. What does that mean if it's not a condition?
Yes, exactly. So, yes, the contract comes into force beforehand, but there's a condition or 3 conditions subsequent. If they're not complied with, then the contract is void.
Where this paragraph may not be helpful is where it says thus rendering reliance on the general rule impossible for the same reasons as it was impossible to rely on. It's not a Cheel case.
It's not a Cheel case at all.
So
it's
that
not a
I
Cheel
see.
case.
That helps me.
And it's also difficult because for the same reasons as it was impossible for the plaintiff to rely on Rule 14 in Cheel. Well, in Cheel, the plaintiff wasn't trying to rely on Rule 14.
No. Okay, so
It's the union. So I'm not sure that takes us a great deal further. It's certainly not authority for the idea that where there is a primary obligation that's breached, you can't have a void provision that engages it. And as you put to my own friend, there are a lot of cases where
but all of them.
Exactly.
Yeah.
Exactly.
Well, not all of them. Most of them. Many of them.
But what you do then have, and the rest, just reading on, is a separate point. In my judgment, the words "unless otherwise mutually agreed" show it wasn't the intention of the parties. So there are a number of reasons why the conclusion there was reached. Now, Kerriam, it's tab 19 of the bundle. I think the only reason that I particularly wanted to show it to you, it's another null and void case. A, it's Court of Appeal. B, it's recent, 1991. And C, it's a situation where very shortly after an agreement is entered into, it then becomes, the argument that it then becomes null and void. So it's tab 19.
And where's this in your skeleton? I haven't picked it up. It's in footnote, is it?
Referred to as one of the cases where
Doesn't matter.
an obligation is imposed on a party. It's paragraph 42, at the top of page 13. It's a situation where a clause providing, this is what I'm reading out from the skeleton, clause providing for a license to become null and void or for breach of contract and not registering an assignment was construed as meaning void at the option of the innocent party. And it's a situation where there was an obligation to register the assignment within 1 month of the assignment happening. That wasn't complied with. The license then is argued to be null and void. So it's helpful for two reasons. One, simply the words null and void are construed in the way that I'm asking you to construe the words here. And secondly, it's another situation. It's a situation of a very short time period when what might be said about some of the other lease cases is that they're very long ones. That's everything I need to say about it. So we say when you take all those cases together, you do end up with the principle as expressed in Lewison, that the contract is to be interpreted, and in his words, so far as possible, not to allow a party to take advantage of his wrong. You see from cases from Davenport onwards that that is a reasoned approach at trying to identify the meaning of a contract, to lean against an outcome where a party is entitled to breach the contract and then avoid the contract he's just entered into. And that makes, we say, complete sense. And we say those cases, together with the FCA as a whole, together with the factual matrix, lead to a construction of that last part of clause 4 as void at the option of. And that certainly does no more violence than the defendant's contention that pledge in clause 6 is pledge at the option of. If I can briefly turn my back and see if there's anything else that I should have said. Unless I can assist further.
Yes, are any burning points you want to raise?
I'll just make a few points just very briefly, and I'll resist the temptation, which your Lordship would avail to me, to re-argue points.
Yeah.
First, and starting with the wording of the agreement, and most of my comments are about the preamble. My learned friend placed particular importance on the title, First Final Clearance Agreement. The point is that it's only a final clearance agreement on the terms and conditions of the agreement. And as your Lordships have seen, clause 7 indicates that final clearance only takes place on full payment. Also, in relation to the preamble, my learned friend focused on the words, the second party has pledged to pay these debts. He tried to suggest that was a reference to the present. It's quite clearly not. It's a reference back to what had happened.
We well covered that in the course of with him. We well covered that aspect
yes,
with him.
absolutely.
Yes.
My learned friend also focused on the word in the preamble, wishes to settle. But again, it's on the terms of the agreement, so it's clause 7.
Well, so that's wording arguably is against him.
Quite possibly so. My learned friend also put emphasis on clause 10, where he said this agreement hereby terminates, but you have to read to the end of the clause in the event of full payment. My lords, in terms of who are the parties to the FCA, it is our case that the parties, and I think we're in agreement with Lady Justice Carr here, that the parties are the defendant in his personal capacity, secondly, acting on behalf of his father, and thirdly, in his capacity as a director of Sard Hospital, which we take to mean hospital itself. We suggest the clue, as my lady suggested, is in clause 12, which is the reference to the powers of attorney, where he affirms that he has the power of attorney on behalf of his father and on behalf of the company.
Does this matter to your argument?
Well, that's what I was going to say. I don't think it does matter to the argument. Even if
I don't think either of you think it matters to the argument.
No. So even if it's construed as my Lord Justice Snowden construes it, I don't think it makes any difference to any of the arguments. No. My Lord, my learned friend took you to paragraph 124 and paragraph 322 in the various statements to try and suggest that indicated that there was an understanding at the time that there was a personal liability in respect to the promissory note.
No, I think
that evidence didn't go that far at all. It didn't indicate that there was an understanding at the time of the FCA that there was a potential pre-existing liability under the promissory notes, and therefore that's not relevant factual matrix. The important point, which my learned friend, in fairness to him, and as one would expect, he accepted quite clearly that there was no prior agreement or understanding to accept personal liability. And your Lordship, Lord Justice Phillips, indicated that absent that type of factual matrix material, maybe quite a lot of this factual matrix evidence doesn't really assist greatly on the critical question of interpretation. Just finally, in respect of Shield and Gillenhammer, we're not here to relitigate whether Gillenhammer was rightly decided. It is obviously rightly decided. But there's a lot in what Lady Justice Hallett says in Hawley, namely that all cases are slightly different. And of course we accept that the facts and the context, the text in Gillenhammer is different. What we say is important is the judge's acceptance there at paragraph 588, that where the clause in question can only operate in the event of breach, that is an indication as to the party's intention that the presumption shouldn't apply. Of course, it's only
well got that point on board now.
Yes, exactly so. So my lady asked whether Gillenhammer was whether Quesnel was in fact a breach
Yes,
case.
I did.
It was treated like that. I think we see that at page 226, where they talk about the question as where it's forfeited for breach. But I take my learned Lord Justice Snowden's point that it's a proviso. But again, I don't think that really matters. Finally, just in respect of the Syrian investment case, well, of course, once again, it's a lease case. So, my lords, unless there are any further matters I can assist with, those are my points in reply.
Thank you very much. We will retire and discuss how to take this forward.
Thank you.
So if you can wait, will only be about 5 or 10 minutes. you to all parties for their submissions on ground 6. We have decided to allow the appeal on ground 6 for reasons which will follow. And so therefore we do not need to hear the remaining grounds of appeal. We will reserve our judgment on those reasons, and those reasons, those judgments will be handed down in the usual way, remotely with no requirement for attendance. Once the draft is circulated, you have the opportunity to submit any corrections or similar comments of a textual nature, not to re-argue the appeal,
Yes.
as per the rubric in the usual way. And also, these days, it's important to emphasise that the rubric will emphasise the need to keep the draft confidential. You'll be aware that there have been cases of breach, and the court will take very seriously any such breach, and there's a risk of contempt of court.
My lords, we're obliged. There will obviously be consequentials
Yes.
in terms of costs,
Yes.
and it seems to me that until those costs issues are determined, it would be premature for me to ask for the money in court to be paid out of court.
Yes.
And also Denton's have indicated that they would want to be heard in relation to that. So I fully accept that I can't ask the court to deal with that. But as your lordships will be aware, there was a post-judgment freezing injunction that was issued against the defendant. So could I hand that up?
I wasn't aware of that.
And
We were not aware of the post-judgment freezing.
oh, I'm sorry. Okay. On the 24th of March, quite a while after judgment had been handed down, the claimants asked for a post-judgment freezing order against the defendant, and that was granted without notice
By whom was it granted?
by the Honourable Mr. Justice Fraser. So could I pass that up? Because what I would ask this court to do, since it was a post-judgment freezing injunction, and now that judgment has been set as, or the appeal has been allowed, with the consequence that the FCA is not enforceable, that there's no judgment debt, no reasonably arguable cause of action.
So I'm not sure the FCA is not enforceable. It's that there's it's what it says.
I'm sorry.
Well, it's a very simple question. Is that a freezing injunction was granted, and we've now indicated that
Yes.
that we've allowed the appeal on the ground that your client is not liable.
Yes, exactly.
So why shouldn't the freezing injunction should be discharged?
Exactly. And so I'd ask for the freezing injunction to be discharged, but without liability to the question of whether there is any liability on the cross undertaking.
Well, that you'd have to apply for, wouldn't you?
Exactly. So I
Yes.
just want to make clear that in discharging the injunction, the cross undertaking and damages is not being discharged, and in due course we'll consider whether we wish to make an application. But on that basis, I think that's the only consequence.
It's lifting the order rather than discharging it. It's lifting the order rather than discharging
lifting
it. If you see what I mean.
Yes.
Yes. Well, the undertaking will continue. Mr. Robinson, this hasn't taken you by surprise.
It has, completely. I have no idea what this was going to be asked for.
One doesn't like to tempt fate.
But at the same time, I think giving a little bit of prior notice would have been... I'm going to ask for a little bit of time to think about that.
Well, what possibly could you say about it?
That's why I need time to think. Because obviously, at present, you've indicated you will allow the appeal.
What we will do is that we will not discharge it today, but we will give you, Mr. Robinson, until 4 p.m. tomorrow. 4 p.m. tomorrow to put in any written submissions as to why we should not discharge it, and then we will make an appropriate order, or if we need to hear from the parties, we will let you know. And of course, all other consequential matters we will obviously invite the parties to make written submissions in the usual way. If you can't agree them, there's this slight complication here that Dentons are interested, but given the decision we've reached, I don't think there'll be very much they can say.
I don't think so.
As the money's in court now will be returned to you, or prima facie they'll be returned to you.
Yes.
It's possible we might have to ask the parties to come back for further argument, but the likelihood is that we'll deal with it on paper in the usual way.
My Lord, if I can just say, from our perspective, we will probably want to deal with those matters as quickly as possible, because some of the money that was paid to the court was borrowed, and I've got no doubt that the defendant would wish to repay that money as soon as possible.
Yes.
So that's just a heads up. We'll try and deal with it quickly.
We understand that, but of course, we've told you today that the appeal is going to be allowed,
yes,
so that we don't hear the other grounds. But in the normal event, that will arise when you get the judgment.
Absolutely.
And was it 1.5 paid into court, or was it varied by agreement?
Sterling. Yes.
1.5 sterling. Yeah.
Yeah.
Yes. Very well.
I'm obliged.
Thank you very much.
Thank you to both parties, all counsel, and to those behind them as well.